Hello, everyone. I'd like to welcome you to today's uh, redo of last week's webinar on marijuana advertising and sponsorship identification. I'm Frank Montero with the law firm of Fletcher, Hield and Hildreth. I have with me my law partner, Ann Crump. Today we're going to be covering a variety of different subjects dealing with marijuana advertising and sponsorship ID. Before we get started, I wanted to thank Justin Sasso and also Amanda Fontaine, Justin with the Colorado broadcasters and Amanda with the Mississippi broadcasters, for helping to put today's presentation together. Also, I want to welcome the New Mexico broadcasters who have joined us for this week's replay of this topic. Fletcher, Hield and Hildreth is a broadcast law firm in Washington, D.C., and we work with the Colorado, Mississippi, and now New Mexico broadcasters on a variety of different FCC-related issues. For those of you who are on here, if you're not a member of your state broadcast association, I strongly urge you to become a member. They do fantastic work, and it's really worthwhile, and they do fantastic work on behalf of the broadcasters in their state. Our firm provides a variety of different services to broadcasters, but we provide a lot of free services to our broadcasters, among them being a blog, comlawblog.com. You can subscribe for free. We post updates on a variety of different legal and FCC-related issues important to broadcasters, and you'll get updates on them every day, covering a lot of the topics that we will be going over here today, as well as many others. We also have a YouTube page where you can just go onto YouTube and search Fletcher, Hield and Hildreth. And there you're going to find a huge library of past webinars that we have done on a wide variety of subjects, including political broadcasting, license renewals, ownership reports, advertising, EAS, and the list goes on and on. And I strongly urge you to go on and review the material on there. Today's webinar is going to last roughly about a minute, about 60 minutes or so, about an hour. And we will be taking questions and answers at the end. So if you have any questions as we're going through the topics, just click on the Q&A tab on your screen and type your questions on, and we'll read them at the end and try to address as many of them as we can. Today's topic is going to cover marijuana advertising, as you know, as well as false and misleading claims in advertising as they are addressed by the FCC regulations, as well as sponsorship identification, which touches on advertising, but also touches on all types of paid content that you may put on your stations and what your obligations are if you put paid content on your stations. Now on to marijuana. Marijuana advertising is largely controlled by aspects of the Controlled Substances Act. I know that in many states, marijuana has become legalized and is widely distributed, and we get a lot of calls from very, very frustrated broadcasters saying, why can't we take advertising for marijuana? There's so much money there, and it seems crazy for us to leave it on the table. Well, marijuana is currently still a controlled substance, an illegal substance under federal law. Many of us know that already. But what people don't realize is that there's a subsection of that same law that says that it is a felony to engage in public communication that would precipitate and encourage the sale and use of any of the controlled substances on the list. That's where broadcasters are in jeopardy, is if they air advertisements for the sale or use of a controlled substance like marijuana, they could potentially be hit by a felony. And that would create big issues. I mean, one is that it could put your license in jeopardy because you'd be using a federal license to violate a federal law. But even if you didn't lose your license, if by some chance you were found guilty of this felony, you would have to report that felony on your FCC filings from here on in, which would be a real burden for you going forward. And
there has been a recent hearing where a person convicted of a felony had his license in jeopardy.
Yes, absolutely, absolutely. The FCC does come after broadcasters for these felony violations. Now, again, the frustration comes over the fact that, you know, in reality, we don't see the federal government enforcing these laws very much. And, you know, you look around you and you see billboards taking marijuana ads, and you see it online, and, you know, why can't we do it? I will note that, yes, the DOJ has largely been hands-off on the enforcement of these laws, with some notable exceptions. When the sale of marijuana involves a distribution to minors, or is in conjunction with a criminal enterprise, where the sale is in states where it still is illegal, when it's done in conjunction with other illegal activity, like the sale of illegal firearms or the like, or drug sales, other drug sales, that could be a problem. In those instances, the Department of Justice has cracked down and gone after them. So at a minimum, you need to make sure that your advertisers are not engaged in these types of activities. Also notable is the Department of Justice has come after marijuana sales folks and advertisers where the marijuana is grown and sold on public lands or on federal property. The FCC itself has cautioned broadcasters to not accept any marijuana advertising. You know, they've made it clear that, you know, the risk is too high with your federal license and you don't want to put your license in jeopardy. At a minimum, I would say to you that if you're contemplating taking marijuana advertising, as I mentioned earlier, please, please, please make sure that your advertiser is not engaged in any of those, you know, illegal activities that I mentioned in the list on the prior slide, sale to minors, and engaged in other illegal activities, you know, or engaged in other organized crime or the like, because then your risk that the federal government will come after your advertiser and possibly you goes up dramatically. I will note that our experience has been that the real risk to broadcasters in these instances is not so much that the FCC is going to come after you. The real risk is that somebody in your market is going to file a complaint against you at the FCC. They're going to, you know, file a complaint against your license renewal or against a transfer application or whatever. It may be a disgruntled employee, it may be a competitor, but they may go, file a complaint against you and say, hey, these guys have run, marijuana ads and that's illegal. Well, when that happens, we have found that suddenly the FCC just freezes in place. They don't have guidance on what to do. So what ends up happening is that your application ends up getting frozen and won't move forward and won't move backwards, and you're stuck unless you can negotiate some type of plea bargain or agreement with the FCC to unstick that application. Because the FCC is very worried, to be honest, about putting out any kind of a ruling that's going to create a precedent that's going to come back to haunt them on marijuana advertising. So they panic and they do what they do best, which is nothing. So that puts you in a difficult situation. I will say also that just last month, I spoke at a conference in New York City with a group of broadcasters, and we were touching on the topic of marijuana advertising. And I took a head count among all the broadcasters on my panel, and I said, so are any of you taking marijuana advertising? Every single one of them said no, with the exception of one who said, we are taking it online on our web page, but we don't put it out over the air. So that tells me that they have made some type of a risk-benefit analysis to determine that, well, maybe, it's less risky to run those ads online. I will be perfectly honest with you. I'm not sure that logic holds up, because the fact of the matter is that regardless of whether you're running the ad, over the air or on your website, you are still technically violating that aspect of the Controlled Substances Act that prohibits the communication of the sale of an illegal substance. And your license could still be in jeopardy, frankly, even if you only ran it over your web page. But they made their own determination on that. So beyond the FCC, where else could problems lie? There are several other agencies that could potentially raise issues here. The Federal Trade Commission, frankly, has not been hugely involved in the issue of marijuana advertising, although they do regulate truthfulness of advertising and the legality of the project, more than the legality of the product. With truthfulness in advertising, frankly, that's also an issue, and it's an issue not just for marijuana, it's an issue for perfectly legal ads for legal products that you run over your station. Like, for example, CBD oil being a good example. But CBD is now legal in most states, so many stations are taking CBD ads. However, you still have to be careful to make sure that your CBD advertiser isn't making some kind of elaborate, crazy claims about their product that are not valid, that'll cure cancer or whatever. And also, I would note, just as a footnote, that the decriminalization of CBD products only applies to topical use of CBD, not to ingestion. So if you have ads that are running ads for consuming CBD products, that's actually not legal, and you should be very, very careful with that. Likewise, the Food and Drug Administration will take action against unproven claims of medical benefits. So again, as I mentioned earlier, with the FTC and the FDA, you want to engage in a multi-part review of your ads to determine, first of all, is the product legal? Secondly, are they making valid or wildly, exaggerated claims. You just have to be careful because, and we're going to talk about this at the end of our presentation today, but you as a broadcaster have some responsibility when it comes to airing ads that may have fraudulent claims. If you have knowledge that those claims are fraudulent, the FCC does put upon you a certain policing responsibility to make sure that you're not using your station to advertise fraudulent products. The last on the federal agencies that I would point out is the IRS and Treasury, and they deal with the federal banking regulations. If you ever wondered why so many dispensaries are an all cash business and they don't take credit cards and the like, that's because the use of the credit cards would involve the federal banking system, and banks are under the same kind of restrictions that the broadcasters are on, and in that they are federally chartered, many of them, and they don't want to put that in jeopardy to have their financial products and their wire transfer systems and their credit cards used for the perpetuation of a product that is still illegal under federal law. Now, just to talk briefly about a couple of gray areas in marijuana advertising. We get a lot of calls. I mentioned that one of the co-sponsors here is the Colorado broadcasters. They were one of the first ones that hit us with this question, where the state wanted to run public service announcements addressing marijuana, like where to put your marijuana, for example, so your children don't get at it, so your pets don't eat it, that sort of thing. They were like, is that okay to run that? I mean, we've come to the conclusion, there are no guidelines on this, but we've come to the conclusion that running a public service ad of this type is okay. That should not be a problem. You are not, encouraging the use of the product. You are merely giving useful instruction and advice to your audience on how to handle this product to minimize any unintentional harm that it may cause. Another one that comes up a lot is physician ads. This is especially true in states where recreational marijuana has not been legalized, but medical marijuana is. Can we run ads from medical clinics or physicians that deal with medical marijuana? For this, I think it depends. And for those, when we get questions of this nature, we usually want to see the text of the ad first. So just to give you an example, if it says something like, hey, come on down and we'll get you your medical marijuana card, that does not make me feel too comfortable, because it really just sounds like what they're selling is the medical marijuana card. They're selling, a way to get you access to medical marijuana. And I would feel a little uncomfortable with that. If, on the other hand, the emphasis of the ad is more of their medical services, come to us for a medical evaluation to determine what is right for what ails you, including, whether marijuana might be right for you, I'm a little more comfortable with that type of language, because, there you are, or the advertiser is really promoting the medical services and the medical evaluation services rather than marijuana itself. And I think that I feel a little more comfortable with that. Then you got things like smoke shops. This is reminiscent of a lot of the discussions we used to have many, many years ago with cigarette ads, right? Can you run smoke shop ads versus something that's called a cigarette shop? what that works. I mean, I think that generically these are okay if you have something that's called a smoke shop. You know, even if it sold marijuana, you know, as long as you don't mention marijuana, I think that would be okay. I'll be honest with you, I'm a little uncomfortable with the use of the word dispensary because dispensary has become so associated with marijuana products, right? I mean, when people hear the word dispensary now, they think marijuana. And, you know, so I feel a little less comfortable with that. That there are, you know, there are some case laws at the FCC that would say that, you know, if you had an ad that said, for say Bob's Smoke Shop, that would be fine. But if it was called Bob's Cigarette Shop, not so good, right? And I think dispensary kind of is like that. Dispensary is almost like a cigarette shop. It screams marijuana. So I'm a little less comfortable with that. But I will say that these are gray areas. There are no, you know, there are no there's no instruction manual from the federal government on this.
No absolutes.
There are no absolutes, right? So I mean, this is one where contacting your state association or your lawyer, you know, really pays off, because sometimes, unfortunately, it's going to be a case by case situation. So now I'm going to turn it over to my colleague Ann Crump, who's going to talk a little bit about some of the state law issues, as well as some of the potential changes that we may be seeing in some of the federal laws. Ann?
Thank you, Frank. Yes, and with states legalizing marijuana on various levels, the advertising is likely to follow, and some states have specifically addressed that. In Colorado, for example, advertising is allowed only where an advertiser has reliable evidence that no more than 30% of the audience is reasonably expected to be under 21 years old. This goes along with the emphasis on not marketing to minors. It applies to alcohol as well as marijuana and cigarettes and all of that, but it's absolutely key. Broadcast ads also should promote only licensed retailers. For example, in Colorado, while it's legal to grow marijuana, the growers are not authorized to sell what they grow. So you want to make sure that what the advertiser is doing is legal, so you're not pushing illegal activity. And that could get you in trouble. On the other hand, laws generally do target the advertiser, not the medium of advertising, the stations carrying the advertising. Still, if the station ad violates state law, the station wouldn't have the defense that, oh, it's only advertising a legal product in a legal manner. That would no longer be true. Moving on to Mississippi. In Mississippi, only sales of medical marijuana to qualified patients are legal. That's qualified patients that are registered to have their marijuana card. Medical marijuana establishments that are the establishments that sell the product generally may not advertise on broadcast stations or in other media. There's a specific prohibition on that. And just to make it super clear, the law adds on prohibitions from running any ad that falls into a number of categories, including those that depict consumption of marijuana. Nobody can sit around looking happy smoking. Includes any health, therapeutic, or safety claims. Includes any images that depict marijuana, like a picture of the leaf or the bud, or again, is likely to appeal to minors or promotes overconsumption. Now, educational materials on the risks and benefits of marijuana use, much like a PSA, and branding activities for the medical marijuana establishments that are authorized to sell, activities such as establishing a website are not considered to be advertising. Therefore, they are legal.
Falls into that PSA exception we talked about earlier.
Pretty much, yes. Also, medical practitioners who are registered with the state of Mississippi as providing medical marijuana services and provide certification of a patient's qualification to purchase medical marijuana may advertise within limits. These limits apply to other types of practitioner ads too, but in this case, practitioners' ads are required to be professional in nature, whatever that means. Don't want to sound like a used car salesman. Practitioners' ads may not suggest that patients will obtain certification regardless of their condition or be designed in any way that entices minors. In fact, practitioners, as in a separate part of the law, are required to advise patients about alternatives to marijuana. In other words, they're supposed to be providing real medical services and advice, not being a pusher.
It's kind of what we talked about earlier about what's the difference between just selling the marijuana card versus actually providing medical advice and the content of your ad.
Right, and likewise, ads that say, you don't need to pay us if you don't get a medical marijuana card,
Yeah, right.
raise clear conflicts of interest for a doctor who's has clear incentive to dispense a medical marijuana card. The ads for practitioners also should avoid the explicitly stated prohibitions with regard to marketing marijuana and should avoid any significant discussion of the benefits of marijuana use. Now, all of this is, of course, subject to change as attitudes towards marijuana generally change. It's unlikely, if everything is done within reason, that the FCC will get involved unless other agencies take the lead. Changes can come from states as they liberalize their laws, the Department of Justice, and or the Federal Trade Commission. States do continue toward greater legalization for medical or recreational use, or both, with differing considerations. President Biden has pardoned marijuana offenders lately, those who've been using. So there is definitely potential for change. Momentum seems to be in that direction with some possible caveats. Taking advantage of this shift, the laws are proposed to be changed in some areas. Last year, the FCC budget bill would have prevented the FCC from taking action like fines or block renewals against broadcasters that accepted cannabis ads as long as marijuana is legal in the state where the station is licensed. But that didn't go through when the Senate removed the language as it went forward.
I want to pause you there because, you know, I think this slide that Ann is going over is important because it indicates how much activity is going on Capitol Hill here in Washington on the whole issue of marijuana. There have been so many bills that have been introduced to deal with, you know, with the marijuana issue that I think there will be movement. I'm not saying legalization, but there will be movement, something, you know, like the FCC budget bill, for example, which did not go through and would only have been good for 1 year because obviously the FCC has to renew its budget every year. But they are looking for some way to get, you know, broadcasters some kind of relief. A big lead on this has also been the banks, right? Because the banks are, you know, losing out on a ton of money as well for the reasons I mentioned earlier. Credit card use. And so they are basically, the banks, as with the the broadcaster is saying, look, if you don't want to legalize marijuana on the federal level, fine, but at least don't penalize us just because we want to either, offer advertising services, offer credit card services and the like. So, yeah.
Right, another of those acts is the Secure and Fair Enforcement Act, of the Safe Advertising Act, which would allow broadcasters to accept ads for legal cannabis product if the station is licensed in a state that permits the advertising of medical or adult use cannabis. Like the House proposed FCC budget, or unlike actually, that this would be permanent and not subject to renewal every year as part of the budget process. Senator Schumer from New York has also introduced the Cannabis Administration Opportunity Act, which would actually bring an end to federal prohibitions on marijuana usage. None of these has passed, as we were saying. And meanwhile, states have been, some of them have actually been having some possibly negative experiences with the legalization and maybe starting to rethink it.
Yeah.
We'll have to wait and see.
Yeah, I think that's right. I mean, I think, the many of the state broadcast associations have been very active, as I mentioned earlier, in trying to urge Congress to address this issue. Just to be clear, not because they are advocating the legalization of marijuana. They're not. That's a topic for someone else to deal with. They are only focused on the ability of the broadcasters to take advertising from this industry as long as it's, it's going the way it is, without the broadcaster being at jeopardy for doing so under this act. And if I had to, make any crystal ball predictions, I think the likelihood of, the Congress legalizing or decriminalizing marijuana, I don't think the likelihood of that happening being very high yet. But I do think that there could be movement on the whole issue of advertising and the credit cards, because I think that there's enough pressure on Congress to at least give those industries some relief.
Right, it's somewhat analogous to casino advertising,
right.
or sports betting advertising, where there's been an argument that, and it was upheld by the court, that it is unconstitutional to prohibit people from talking about activity that is legal in the state where they're advertising.
That's exactly right. That's exactly right.
And so I will send this back to Frank now to talk about false and misleading advertising.
Yeah, I mean, this goes back to what we were talking about earlier, where we mentioned that say the Food and Drug Administration or the Federal Trade Commission could come after ads that are, false or misleading, or make false or misleading claims, even when the product is 100% legal and can be advertised. You can't make false claims about the product. And the FCC also has requirements in this regard. The FCC sees broadcasters as custodians of the public airwaves, and as custodians of the public airwaves, they have an obligation to their audience and to their listeners, and they are responsible for not engaging in any activity which they knowingly will result in, in some fraud or misleading their audience. So in this respect, broadcasters do not have, blanket liability if you put on an ad that makes a false and misleading claim. But if you run an ad that is making a false and misleading claim, and then somebody comes after you or comes after the advertiser and you and they can prove that you knew of
Or
the false
should have
admitting
known.
or should have known, right? That can create an issue for you. So you have to be very, very careful with that. Excuse me. And as I mentioned earlier, the Federal Trade Commission likewise is always fielding complaints on medical devices and products and the like. I touched on CBD earlier, CBD, weight loss and the like. So just be very, very careful that if you become, aware or have reason to believe that a product that you're advertising is false, you have to sort of, that you are not free of obligation in that respect.
Yes.
Sorry.
The one exception being political ads, but that's a
Well,
separate topic
that's true.
altogether.
That's another topic altogether. There is an exception,
By
and
candidates.
Anne makes a good point that there is an exception.
That's the only exception.
Where if you are taking a candidate political ad, that's one where you have to charge lowest unit rate within the window before the election. That in those instances, you are not allowed to edit or change the content of the political ad. The trade-off is that if that political ad has false or libelous claims, you are exempt from those ads in exchange for your obligation to have to air them.
But aside from that limited category, you're
Right.
expected to use the rule of reason.
The other thing that you should be careful with are hoaxes. These are either hoaxes that are in an advertisement that you may run, or hoaxes that you just may run, little games or or the like that you may run on the air to your audience. Basically, the FCC does have rules that prohibit broadcasting false information. If the licensee, if you as the broadcaster, if that false information basically checks three boxes. One is that you as the broadcaster and licensee knew that the information was false, that it is foreseeable that airing that information would cause substantial public harm, and that three, airing the information does in fact cause that harm. Then, you can be found liable and be fined by the FCC. There is mitigation steps that you can take by, for example, airing a disclaimer. By airing a disclaimer, it is presumed then that the harm was foreseeable, or that it does not pose a foreseeable harm if the disclaimer clearly characterizes the program as fiction and is presented in a reasonable way under the circumstances. And I will also mention that we here at our firm generally, urge our clients that it's probably a good idea internally to, have some system of guidelines to for your on-air folks regarding, false, misleading, or deceptive claims, just to kind of discourage that kind of activity, to know what these definitions are, to know what the three-part test is, to know when to put on disclaimers, to minimize the risk to the station.
Yeah, make sure somebody doesn't get a bright idea and just run with it.
Right. Last but not least, we touch briefly on sponsorship identification. This should be a topic that all of you are already pretty well familiar with, but I think it always warrants a little bit of a refresher. Sponsorship identification basically applies to any programming that you put on the air in exchange for something of value. If you receive something of value, which we lawyers call consideration, for airing that content on the air, And that, by the way, that consideration doesn't have to be cash. It can be goods, it can be services, it can be a variety of different things.
Including the programming material itself.
That's exactly right. That's exactly right. But if you air that, then you have an obligation to identify the sponsor who paid or promised to pay for the broadcast of that material. You have to disclose it on the air. This, by the way, is a corollary of payola and plugola, another topic that many of you, I'm sure, are very familiar with. It's a common misconception with payola and plugola that I hear people, a lot of broadcasters out there think that payola is basically paying money to have, like from a record company, paying money to have their record played. That's not the what triggers the payola. What triggers the payola is paying money to have the record played and not disclosing it. If you disclose it, if you were to say the following record is brought to you by Sony Records, the following record is brought to you by, or has been paid for by Warner Bros., then suddenly you have sanitized the payola, and there's no payola violation. So it's really just a matter of putting the sponsorship ID out there so that the public knows that what they're hearing has been paid for. Plugola, as many of you already know, is plugging a product or a service, restaurant or what have you, a business, in which someone at the station or the owners of the station or the on-air personality that they have a financial interest in that business. They need to disclose that as well. Otherwise, you have a plug violation. In time brokerage arrangements, I should start out by saying, with a time brokerage agreement, your programmer, if you've brokered your station out, or if you are yourself a broker, you have an obligation to comply with these sponsorship identification. If the broker does not comply with these sponsorship ID rules, the licensee can get fined. It's one of the reasons why a lot of times in time brokerage agreements, you will have included plugola affidavits, that they'll have the programmer's employees sign plugola affidavits or payola affidavits to minimize the risk to the license holder that they might violate the sponsorship identification rules. Also now, we have a whole new set of rules dealing with foreign sponsored programming that also has to be disclosed. So you need to be up on those rules as well to comply with the FCC's requirements.
And there's a pending rulemaking on exactly what will be required.
Exactly right.
Standardized language.
That's exactly
but
right.
But that hasn't been adopted yet.
Yep. The one thing that with regard to sponsorship ID is that if an ad, for example, if it's plainly obvious that it has been sponsored by, like a Coca-Cola ad, for a Coca-Cola product or Budweiser or whatever, and it's pretty obvious that it's an advertisement. In those instances, the FCC has said you do not have to put, sponsored by Anheuser-Busch, sponsored by Coca-Cola. If it's plainly clear from the content of the ad that it's sponsored programming and who sponsored it, then that may be enough in and of itself.
The basic concept is the audience is entitled to know by whom it is being persuaded.
Right.
Persuaded. And if it's not announced to the contrary, they will assume it's the station.
Right. Before we take questions, I just want to sort of circle back on something that Ann touched on earlier, which is political. We have not done a deep dive into political advertising in this presentation for purposes of sponsorship identification. There just isn't enough time. We've got plenty of webinars on that topic on our YouTube page, but as Ann pointed out, political ads also have some of their own unique sponsorship ID issues that come up. There's the one that she mentioned earlier about being sort of exempt from content liability in an ad, but the trade-off, of course, is that you must air the ad without alteration. Yes, the FCC is basically imposed on broadcasting. If you're going to federal ads that must be run, or state and local ads, for which it's discretionary, but if you decide to run them, you cannot alter the content of those ads. But the trade-off is that you get you get some exemption from liability. But likewise, with those ads, as well as issue ads, there are requirements that involve sponsorship identification, categorizing those ads and putting that information into your public inspection file. You have a political file in your public inspection file, that political folder, that where you have to put detailed information on who purchased the ad and the like. And so just know that with political ads, there's a whole other subset of sponsorship ID requirements that also involve your public file. And if you want more information about that, again, we've got plenty of it on our blog, on our YouTube page, or feel free to contact us. We put our contact information up on the screen here if you want to reach out to us. And that is the end of our presentation. We do have time for a few questions here. So I'm going to read a couple. Let's see. First one is, where would podcast or even on-air shows stand as far as educating the public on the use and benefits of marijuana? Do you want to take that?
Yes. That would be a bit problematic, I think. I don't think that there is an actual prohibition, but you definitely would want to avoid paid programming on this.
Yeah, that would be my take as well. I mean, I think with paid programming, if it was like, an infomercial, that might be an issue. If on the other hand, you were just engaging in, if it was an interview program, just talking about, about marijuana, about, accessibility of marijuana in the community, that sort of thing.
I'd want to make sure any talk about benefits was really scientifically based and had factual things back it up, so that.
Yeah, I mean, I think there's a certain amount of of leeway that you would have in just say a news program where you're just sort of talking about, you're not urging the use of marijuana, but you're just talking about, what is said about marijuana, and even what's said about the benefits of marijuana. I guess I don't have a problem with that so much.
Probably want to balance it with some of the risks as well.
Right.
And a podcast would be much freer because it's not specifically regulated.
Well, that's exactly right.
The same way that broadcasting is.
A podcast is more like a streaming vehicle, and it's not going out over the airwaves. So there's that as well. Exactly. We have another question here. Let's see. What about city of license issue? For example, some stations have studios in Memphis, but have a Mississippi city of license. Would a Tennessee city of license be treated any differently than a Mississippi city of license? That's actually kind of an interesting question, because
The
I
answer
guess,
is yes.
yeah, I mean, I think
If it's not legal in Tennessee and you're in a Tennessee city of license, even though you're covering Memphis the same way that the Mississippi city of license station is, there is a difference.
yeah. Now, mind you, keep in mind that what we've been saying all along is that, you know, marijuana advertising is illegal, or marijuana is illegal. Marijuana advertising, I think, also illegal on a federal level. So it really doesn't matter whether you're, you know, whether you're in Memphis, you know, or if you're, you know, in a neighboring city, that you're it's good, it's illegal. Federally illegal is federally illegal. But you know, as a general rule, this topic comes up a lot with things like, say, sports gambling advertisements, right? Where,
Casinos, state lotteries.
or state lotteries, exactly, where, you know, it might be legal in one state, not legal in another state. You have a signal that leads over. You used to have this issue a lot with casino gambling back in the
Absolutely.
day as well, where we're legal in one state and illegal in another state. So the answer is yes. I mean, it's very fact specific, you
It's
know,
very frustrating for many people.
right?
On each side of the border.
But I think that it is one where if you know, if your signal, it's not really about your city of license, because, I mean, I would say that if your signal extends into the neighboring state.
No, it really is about the city of license.
Really?
Yes, there have been cases on that in the past.
So if your signal extends to the neighboring state, then you would not look to impact on the neighboring state, you would just look to the city of license?
That's right.
Okay, I stand corrected. And let's see. I think that is all we've got here. Any other questions? Okay, well, with that, I want to thank everyone for attending today. Again, please feel free to take a screenshot of our contact information there. This presentation will also go up on YouTube in the days to come and be accessible. Again, I want to thank the Colorado broadcasters, the Mississippi broadcasters, as well as the participating New Mexico broadcasters for being in on this program today. And we'll see you at the next webinar in the weeks and months to come. I hope everyone has a very, very happy holidays. Bye-bye.